My name is Loukas Mistelis. I'm the Clive Smith Professor of Transnational Commercial Law and Arbitration, and I'm responsible for a lot of the offerings we have in international dispute resolution and more particularly arbitration. The module I will be presenting briefly is International Arbitration Law and Practice, Theory and Context, and this is our flagship arbitration course, which is mandatory for all students that take the LLM in dispute resolution. It's not only mandatory, but it's also compulsory and exclusive, because only students in the specialization can take that module. We also offer a separate module on arbitration, which is open to all LLM students. Therefore, this module is designed to be an advanced arbitration module. So we provide sort of the broader theory and context of arbitration. Therefore, we look at how arbitration has evolved, how arbitration is being regulated these days, and how arbitration sort of works in relation to national courts and national law. So in this module, we take you from the beginning of the arbitration agreement, how a tribunal is constituted, how a tribunal establishes its jurisdiction to decide disputes, and then we move issues of policy, public policy, ethics, regulatory concerns, issues like third-party funding, for example. And then in the final part, we look at the outcome of the arbitration, the award, how an award can be challenged, and of course the enforceability of awards. In doing that, and throughout the course, we do not focus on a single jurisdiction. It's a comparative module, and therefore we'll be looking at various jurisdictions, the key jurisdictions in the world, which involve, for example, France, Switzerland, the US, the UK, but the ancestral model law. But depending on the student population, we are focusing on particular issues in particular jurisdictions. If in a particular year we have a number of students from Brazil, or from Nepal, or from Nigeria, we will also be looking at the local laws, because everything has to become relevant to the individual student population. And I think that's the beauty of this course, because it's generally comparative, and every year we have between 30 and 40 nationalities in the class. We will inevitably sort of learning from each other, and not just from the teacher to the students and back. The module is assessed in a very classical way through an exam. It's a take-home exam, and you have quite a bit of time to answer your questions. And your studies will be supported by specialist small group teaching, supported by people who are associated with the school. I will be giving the majority of the classes, but as it's very useful for all students, we are going to have a number of guests. We are going to be exposed to different ideas, and I always like to have my ideas being challenged. One of the final key features of the course is that we also have a couple of scheduled roundtable discussions. We bring together a number of arbitral institutions. Arbitral institutions are key to international arbitration process. And in these roundtables, institutions present their own perspectives and also what is their contribution to the arbitration process. It is very useful for students historically to interact with institutions and experience not just the arbitrators or the lawyer's perspective, but also the institutional perspective in the process. So it's a very advanced, but also very fundamental module, covers from the basics to the very advanced level that we would expect all the students will attain by the end of the class.